Can everyone see that?
Yep, I think we're good. Okay, well, welcome everyone. Thanks for joining us. This presentation will cover press rights for high school student journalists. As Professor Norins indicated, I'm Taran Harmon Walker, and with me is Navroz Thorani.
Hi, everyone.
We are law students that work with the First Amendment Clinic at the University of Georgia School of Law. This presentation isn't necessarily aimed at making y'all First Amendment experts, but we hope that this information will help you get an understanding of the state of high school press laws and freedoms in Georgia and how they may change in the years ahead. So let's get into it. All right, so that's the Constitution up in the upper right-hand corner there, or at least the beginning. It includes the First Amendment as an amendment to its Constitution at the end. The First Amendment includes strong language that limits government interference with freedom of speech and freedom of the press. And so here it is. Congress shall make no law abridging the freedom of speech or of the press. So this is a quintessential guarantee of the Constitution. At times, though, speech and press rights do brush up against other important freedoms, and so a balance must be struck. The classic example is yelling fire in a crowded theater, which might cause a panic that could get people hurt, threatening their life, which is also protected under the Constitution. Another example could be slander, maybe making a false statement about someone that they're a serial killer. That is not something we want to protect. Nonetheless, this First Amendment is a promise by the government that it will not interfere with the rights of its people, including its youngest citizens, such as student journalists, and their ability to express themselves and report the news.
So beyond the fact that the Constitution allows free speech, there are several theories for why it's important to protect the rights of free speech and free press. First, we have to create an informed citizenry. So a healthy democracy requires educated and informed citizens that have access to the most current ideas and the most accurate information from a wide variety of sources. So the marketplace of ideas is where ideas and opinions are debated, with the hope that the most valuable speech or the truth will emerge. Second, we have the watchdog theory. So the press keeps an eye on those in power, they inform the public, and they allow us to hold public officials accountable. The media is often referred to as the watchdog of the government. And lastly, we have the conscience of society. So some argue that it is the responsibility of the news media to bring about needed social change. And so this theory of the conscience of society looks to the media to identify and publicize social problems and injustices in order to improve the plight of the underprivileged. Now, although the Constitution and these ideals protect free speech, in practice, there can be a number of hurdles. Historically, censorship has been one of the main hurdles that students have experienced and reached out to outside legal help for. So when we consider a case of censorship of high school student journalists, we're really asking this question. What authority do school officials have to control the content of high school student media? And we ask this because some forms of censorship are allowed and some are not. But before we answer that question, of whether school officials can censor student journalists, let's make a quick distinction between public schools and private schools. The First Amendment only prohibits censorship by the government, not private individuals. And because private school administrators are not government officials or state actors, they do not have to comply with the First Amendment. So public school administrators, on the other hand, they do have to follow the First Amendment because they are government officials. So therefore, public school officials must abide by the First Amendment in regard to student speech. But private schools are not restricted by the First Amendment. Some private schools do choose to adopt policies that mirror First Amendment protections for their students and employees, and state law in some places can also create protections for student speech. And we'll talk more about those state protections later when we discuss the New Voices movement.
Now then, let's break down censorship a bit. What is censorship? Censorship is the suppression of speech, communication, or information. It is in direct conflict with the freedom of speech and freedom of the press. Some forms of censorship of school journalists are obvious and direct, and they can be performed by either school administrators or the teachers who advise students. Some examples include cutting a specific story or photo, or stopping a student reporter or photographer from covering a news event, or pulling the plug on a student TV or radio show because of its content. Another example might be restricting access to a student media website or a social media account, including blocking a student. Or further, another example might be canceling or confiscating an entire issue of a student publication, or suspending or disciplining a student journalist for something they've written. Now, censorship can also be indirect, like where someone self-censors or where speech is discouraged or what we call chilled. Self-censorship is when someone, including a student, decides not to speak because they're concerned about the possible consequences. Meanwhile, chilled speech occurs when a rule is overly broad and a student assumes that their speech is prohibited or would be punished when really it would be protected by the First Amendment. So what are some examples of indirect censorship that might result in self-censorship or chilling? Well, firing an advisor because the advisor allowed their students to publish certain content. That might cause students and their advisors to self-censor in the future to avoid adverse consequences. Or school officials might pressure student journalists not to write about certain subjects or to put a positive spin on a topic. That is also indirect censorship. And then when school officials cut funding to student media after they express an unpopular or controversial viewpoint, that might also result in self-censorship or the chilling of speech. So now sometimes students, actually pretty often, edit each other, right? And student editors are a primary function in official student publications. So when they edit each other, is that a form of censorship? Well, that isn't so much a suppression of speech as it is a normal and necessary part of the collaborative process of news reporting. Students aren't government officials anyway, so it isn't censorship when a student editor changes or decides not to publish a staff reporter's story, unless they're pressured to do so by a school official.
So when we're discussing First Amendment rights in public schools, we have to start with the most important Supreme Court case regarding student speech rights, and that is Tinker versus Des Moines. On December 16th, 1965, a small group of junior high school students in Des Moines, Iowa, wore black armbands to school in support of Robert Kennedy's position to call a Christmas truce in the Vietnam War, and also to mourn the death of those that had already been killed in the war. Among those students was an 8th grader named Mary Beth Tinker, whose family had a long history of advocating for peace and social justice. Now, the school prohibited the armbands and the students wore them anyways. The principal suspended Mary Beth, and eventually, the school suspended a total of 5 students that included Mary Beth's high school age brother and a friend, Chris Eckhart, for wearing armbands to school. In 1969, the United States Supreme Court handed down its decision. The court said that neither students nor teachers shed their constitutional rights to freedom of expression or speech at the schoolhouse gate. And the court announced that school officials could only censor a student's on-campus political speech if the speech, 1, invaded the rights of others, or 2, created a material and substantial disruption of normal school activities. There have been very few cases where courts have actually found student expression disruptive enough to justify censorship. It's not enough to simply show that the speech is controversial or that it could offend or hurt the feelings of listeners. In most instances, the courts have required the school to show that the speech is reasonably predicted to create a serious physical disruption that would not allow normal school activities to continue. Courts have also required that before school officials can censor on-campus speech, they must have more than just a hunch that a disruption will occur. They must be able to point to information or evidence supporting that a serious disruption of school is reasonably likely to occur. So school officials do not have to actually wait for the disruption to occur before censoring speech. But again, they must be able to point to evidence supporting that the speech would likely lead to a substantial disruption.
Now let's talk about Georgia, where we are. In Georgia, the Tinker Standard was used to protect high school press freedoms in the only Georgia case to date to deal with high school journalism rights. This case, Reinecke versus Cobb County School District. In 1979, the student editor-in-chief of the Arrowhead newspaper at McEachern High School noticed that several changes had been made to the content of the issue without the students being told or giving consent to changes. So one swear word was changed. A paragraph that indicated the teacher's views on homosexuality was removed. An article quoting a school board member's segregationist ad from 20 years prior was removed, among other changes. Once the newspaper started to sell, the principal then ordered it to be stopped and confiscated all of the copies already sold, another form of censorship. Then the next issue of the newspaper was also censored, including by removing an article about the previous issue's confiscation. So when the father of the editor-in-chief of the student newspaper brought this case to court, the court applied the Tinker standard. It found that the court is unable to discern any reason why the publication of this article would have led to a substantial interference with educational activities. It is the court's conclusion, after considering all of the evidence before it, that the article's appearance would have, at most, provoked discussion and comment among the students at McEachern. The court said it was unreasonable to equate the possibility of controversy or adverse reaction with a substantial likelihood of disruption, and that's what the Tinker standard cares about. So improving appearances and removing a swear word was not enough to justify that school's administration's concerns, even if the principal or journalism advisor found the articles or words offensive. This Reinecke case shows how Tinker was used to protect high school journalists' speech and press rights in Georgia back in the early 1980s. And the case has never been overturned by Georgia courts.
Now, although that is great for Georgia, 8 years after the Reinecke decision, the Supreme Court decided a case called Hazelwood School District versus Kohlmeyer. Justice White, in the top right here, wrote the opinion in this case. In Hazelwood, the principal had cut 2 articles from the school paper because he deemed them to be inappropriate. One article was about teenage pregnancy, and the other was on the impact of divorce on students. Now, instead of applying the Tinker standard, the Supreme Court said that school officials could censor student speech and school-sponsored media when the censorship was reasonably related to legitimate pedagogical concerns. So the question is there a reasonable educational justification? And how do we define that? In the decision itself, the court says this includes speech that is ungrammatical, poorly written, inadequately researched, biased or prejudiced, vulgar or profane, or unsuitable for immature audiences. So as you can imagine, this language has been construed very broadly over the years. So the court thus gave school officials broad discretion to decide what is or is not appropriate content and language for school-sponsored journalism, significantly reducing the level of First Amendment protection to student journalism.
Now back to Georgia. As we saw in the Reinecke decision, the Georgia courts used the Tinker standard to protect high school journalists' expression in the 80s by requiring school officials to show that the speech was likely to disrupt school activities before censoring student speech. Technically, a material and substantial likelihood of disruption. But since the Supreme Court's Hazelwood ruling, student journalism receives less protection than other speech according to federal law. This is because high school officials can use their discretion to censor high school media without having to show that the censored material was likely to disrupt school activities. In other words, after Hazelwood, and in Georgia, the Tinker standard for students' free speech no longer applies to student journalists in their journalism. And journalism advisors in Georgia also have limited speech rights when it comes to protecting their students from censorship. The Georgia Department of Education Standards of Excellence actually require advisors to censor students' work as is authorized in Hazelwood. And if advisors don't follow these standards and instead stand up for their students' free speech and press rights, they could be subjected to negative performance reviews or even disciplined. As part of our research, we interviewed high school student journalists from across the state who generally indicated that they avoided writing about or publishing controversial or sensitive topics, even when they considered the topics to be important. They said they tried to please the administrators and avoided politics or religion or anything controversial. Some high school students, journalists in Georgia, have expressed that they have even been told directly by their schools not to write about current relevant topics, such as the Black Lives Matter movement. Generally, the role of the press is to put a spotlight on controversies. And who better to report on what's happening in schools and local communities than those who live there, especially when there are no local news sources other than student journalism's around. We also interviewed advisors. In one of our interviews, an advisor told us that a principal canceled the annual April Fool's edition of the high school paper because he felt it wasn't appropriate given the seriousness of the COVID pandemic that had just started last year. Not only was the edition canceled at the last minute when all of the work had already been done, but there was no discussion about whether the students could use some lighthearted levity at that time. And the advisor was required to tell the students the principal's decision rather than the principal announcing it himself. The advisor talked about how she felt powerless to protect her students from this interference. Overall, it is clear that in the aftermath of Hazelwood, the speech of Georgia student journalists and their advisors is both censored and causes self-censorship and chilling. In other words, student journalists may self-censor and not report on certain things because of fear that the administration will cancel them or punish them. And advisors can't stand up against the censorship without risking adverse employment consequences themselves.
So what have states done about the lack of student press freedoms after Hazelwood? In the more than 30 years since Hazelwood, some states have been passing their own laws that protect the speech and press freedoms of students, and particularly student journalists. These state laws are often referred to as New Voices laws. New Voices laws restore Tinker-level protections for all student speech so that school officials have to show that speech is either unlawful or disruptive before they can censor it. New Voices laws remove school officials' authority to censor speech simply by declaring that it's either poorly written or inappropriate. Now, many of the New Voices laws also contain protections for journalism advisors to keep them from being fired or punished for standing up for their students. So far, 14 states have enacted legislation to provide these protections for student press freedoms, but unfortunately, Georgia is not yet one of them. The map in the upper right corner shows states that either have enacted New Voices legislation or that currently have campaigns to enact legislation. The states in green are those that have New Voices legislation, and the states in yellow are the ones that have active campaigns right now. If you're interested in learning more about New Voices and how it could work in Georgia, you can contact the Student Press Law Center at splc.org. The Student Press Law Center is a nonprofit organization in Washington, D.C. that works to promote and support First Amendment and press freedom rights for high school and college journalists.
We hope you found this presentation informative and it helped provide you with a foundation for understanding your rights as student journalists and advisors. And so at this time, we'd like to ask, do you have any questions for us? We will try to answer.